Welcome to Willis Weighs In. I'm Ben Willis, contributing editor with Tax Notes. First, I've gotten some questions and compliments about the intro music. For those of you who have asked, feel free to check out Cappy D and McFeely. Special thanks to my good friend, Neo. Now, today I'm here with William Alexander. Bill's impressive career has over 25 years of experience at the IRS, as well as over 5 years in his current role at Skadden. Bill was the Associate Chief Counsel Corporate at the IRS's Office of Chief Counsel, and he and I actually overlapped for a bit while I was in Treasury at the Office of Tax Policy as an attorney advisor, and we worked together and had a great time for a year or so. So, without further ado, Bill, I am so excited to have you on today's show. Thank you for joining us.
Ben, thanks for having me. I'm delighted to be here.
Absolutely. How are you today?
Just fine, thanks.
Glad to hear it. All right, well, let's dive in, Bill. I think folks would be most curious to hear about what's going on with respect to the current situation and the IRS's guidance practice, particularly with respect to PLRs and other guidance. I know while I was at the IRS and Treasury, there was a big shift in the PLR program. There were a lot of significant, I shouldn't connect significant with no rule, but there was a lot of big no rule items that prevented taxpayers from coming in when I originally got there. And that shifted throughout my course of the time at the IRS and has continued to shift since then. PLR practice has expanded, and the IRS has reached out and extended an invitation to taxpayers to come in for more rulings and guidance. And I think this is a great thing for taxpayers, also for transparency. It helps the IRS build and learn knowledge. And I know that Bill has been extremely generous with respect to ensuring that taxpayers get the guidance that they need. In fact, I'll kick off just by giving a little background as to when I first met Bill and respect to this topic. So we met at a BNA luncheon on January 5th, 2010, where I brought up a potential ambiguity with respect to Cash D reorganization regulations that had just been issued. And in short order, Bill's team quickly put together some regulations clarifying what would be viewed as a potential ambiguity in those regulations. Bill, you actually were fantastic during the discussion that day, and afterwards I was really inspired to get together with you, and we had lunch shortly thereafter, and you really exposed me to government and the good that it can do for taxpayers. So thank you so much for doing that.
Well, Ben, I want to thank you for that was one of your earlier contributions to the fabric of our country's tax law, and it was very helpful. And I must say that you must have an incredible record-keeping system if you could remember exactly when we first met 10 years ago. I don't know how you did that.
I wish it was my organization, Bill. I can attribute it to the fact that I got married 5 days later on 10/10/10, and so that's how actually I remembered it. It was a big deal for me to speak up in that forum and to get such a great reception, and so it was very memorable for me.
Well, I agree that your marrying Stephanie would have been memorable, even if meeting me would not have been. But I thank you for that and for your continuing contributions to our field. When you raise the subject of guidance, I think the first thing that has to be said is that our friends in the government have been doing an incredible job publishing guidance about under the CARES Act and about the pandemic. It's really heroic considering the circumstances they're working under. And in fact, in the work that they've done implementing the TCJA, you can tell they've had a hard homework assignment, and they've done some really impressive things, and quickly for the government.
Let me just echo that sentiment. I know I've written a lot on Treasury Actions, and I think that they've done an incredible job at all the regulations and guidance they've published over the few years that have passed since reform, and I must applaud their efforts, just like you.
Let me go to the topic of PLRs, which you also raised. That's a different type of guidance. I mean, in theory, it's not as efficient as writing regulations or revenue rulings, because it's one taxpayer at a time instead of for the whole country. But it's nevertheless, I think, a very important tool. I was very fortunate because when I got to corporate at the IRS, corporate already had a very effective ruling program, and one that was very highly regarded, and for good reason. And I think it's a useful tool for the government. It lets the government learn about transactions. It lets the government address issues that would perhaps not merit a full project for published guidance. And it lets the government try to work things out in a lower risk environment. Obviously, the government is never that casual about the decisions it makes. Government lawyers are professionals and very careful, and they do very good work. But it's nice to be able to deal with an issue for the first time in an environment where you're not making promises to the entire country, and I think one of the reasons why corporate's ruling program was in fact so successful and remains successful is because it basically treats the private letter ruling program as though the premises on which it exists are for real, which is to say that it is not in fact binding precedent, and that it is basically, as an administrative matter, a conversation with the taxpayer and the exam group, which the rest of the country is fortunate enough to be able to look in on, but is not really a party to. And I think when you approach rulings in that spirit, it enables you to work through the problems in a practical way. And so, for example, long before I got to corporate, the design of a letter ruling from corporate is that you have a lot of facts, and then you have the holdings. And what you don't have is an essay about why the holdings are correct. Because if you approach the letter ruling as a conversation between a limited number of parties, you wouldn't write that essay. And so, in fact, corporate doesn't. And that makes it a lot easier to write a ruling in a way that makes it a lower risk proposition for the government. Similarly, when I was there, I was very reluctant to revoke rulings, even if on further reflection, our group felt that we would no longer issue the same ruling again. And we might say publicly to people that we would not issue the same ruling again, that we changed our mind and that we thought better of it. But I think institutionally we felt that revoking a ruling, private letter ruling, tended to validate the rest of the corpus of rulings that were not revoked in a way that was not useful to the program. Different groups at the IRS have approached this problem differently, but this was always my view.
Well, I always believed that practitioners and taxpayers at large viewed your approach to dealing with guidance and PLRs as very successful and fulfilling the mission of the IRS and helping taxpayers determine their obligations. And so I know I was always a fan for that reason, and I know many others were as well. You mentioned a point that I find interesting, which is with respect to being hesitant to revoke prior guidance. And switching gears just a little bit here, what's coming to mind now is a revenue ruling that I know taxpayers argued should be revoked for a long period of time, or actually I should say obsoleted. I would say most of the justifications, and the ruling I'm talking about is Rev Rule 78-130. That's the double drop and check ruling, which was received some scrutiny after a 1984 change in the control definition of dereorganizations. A lot of folks thought that the ruling should be eliminated for that purpose. They believe that the law change made that ruling no longer relevant. And since then, we've had some changes. I believe Rev Rule 2015-10 addressed the double drop and check. Well, that was -9, and the triple drop and check issue that stems from that. But I'd be very curious as to your thoughts on some of the logic underlying that issue and how folks should address these types of issues as to whether or not guidance should be revoked, if there's some sort of a law change, or if there's another reasoning for eliminating a rev rule.
Well, the concerns that I raised in the context of the PLR program about revoking rulings, don't exist when you're dealing with a revenue ruling. Revenue ruling is something that the government is committed to, assuming that the statute and regulations that it interpret are still in force. And so it's important that the government still believe in it, and if it doesn't, the government should change it. That particular ruling was an interesting case because I think many of us in the government approached 78-130 as initially as something that was rendered obsolete by the 1984 law change to dereorganizations. And yet what you will see in the 2015 rulings is that, in fact, the 1978 ruling was declared revoked rather than obsolete. And these two words are used differently. Obsolete means that a law change has occurred that makes the bottom line answer no longer, or some part of the answer no longer valid. And a revenue ruling is, in a sense, in its most direct administrative sense, an instruction to revenue agents. And so if that instruction is no longer valid, something should be done to make sure that it's not followed. In theory, the ruling can be obsolete even if the government doesn't declare it obsolete, but there was some thought that it should be declared obsolete, that the government show its agreement with many taxpayers who advocated that view. But in the end, what you'll see is that the 78 ruling was revoked. Revoked means that the government came to think that there was at least some aspect of the ruling that was wrong on the day it was published, even back in 1978. One of my colleagues in government very forcefully and persuasively made the case that the reasoning behind the non-application of Section 351 was in fact never correct. And in fact, that rationale is expressed in the two replacement rulings from 2015. The other interesting aspect of that regulation is, of course, that anytime you write about whether a form will be respected or a transaction will be recast in the corporate tax area, you get into all sorts of interesting issues of policy and history behind the statute. Certainly this is no different. And it was very interesting to me because the ruling was published actually a bit after I left the government. And it was interesting to see how the, in the end, the discussion of that issue was expressed in the ruling. It's a revenue ruling project is kind of fascinating because people imagine, never worked on one, that it's really easy to write a revenue ruling because it's a relatively short document and it's geared to only one set of facts, and in fact a set of facts that the government can make up, which in theory could make its life easier in drafting the ruling. But in fact, it's worked on by a group of people, and it's a rather short document, which means that almost everybody who sees it feels that they can edit it almost as soon as they read it. And so a document like that actually goes through countless drafts and takes a very long time to produce. When you start, you never know where you're going to finish. Although I think the government did a very nice job in the way that they finished. And in reaching a conclusion that the transaction did not need to be recast other than the traditional dereorganization at the bottom of the triple drop and check.
Well, I must agree with you. I think the IRS certainly did come to the appropriate conclusion, and I appreciate that the clarification. It seems like revoking was the best result. That's partially based on my own views, which is with respect to the step transaction doctrine. And I think that's really what you're getting at there, where they were able to respect the contribution, the 351 contribution, and instead of rendering it obsolete because of a law change, they revoked it because there was a misapplication of the step transaction doctrine, and that the initial transfers perhaps should be in fact respected, which I think was the ultimate conclusion. And so it's certainly an interesting issue with respect to step transaction. And I guess it brings up this old adage that probably you and I have heard more times than we'd like, which is that a form should be respected except when not. And so, as corporate practitioners, which you and I have been for a large part of our lives, we're often dealing with the characterization of transactions, which is obviously an incredibly important step. It's a layer that you really must start before beginning a lot of other determinations, such as international implications of a transaction and so on. And sometimes the international rules and policies will actually affect a characterization, but generally speaking, I think these substance over form principles, when they are applicable in accordance with congressional intent, they really govern and drive the tax consequences of a transaction. And so I guess that makes me curious as to how often you deal with substance over form and step transaction, and now that you've been in practice for over 5 years and are dealing with clients frequently.
I've dealt with it throughout my career. I've dealt with it at Skadden. I dealt with it at the government. I think if you work in the corporate tax area, questions about substance and form and the step transaction doctrine and recasting transactions are, part of the thing that makes this narrow corner of the tax law so intriguing and so fascinating. I've sometimes said to people that one of the reasons why I come to work every day is because I'm convinced that, well, this is the day that finally it will all make sense, and will rationalize all of these authorities about when you do recast and when you don't recast, and how you do this. And the next day, of course, I come to work thinking that will be the day when I finally figure this all out. When I worked in the government, in a way, enjoying working with this was something of a guilty pleasure, because as the tax administrator, you really wouldn't want to set out to design a system that was so subtle that you couldn't figure out all of the answers and produce predictable results. And in some ways, that's what we have. But it is fun to work with. I will say that when I was in the government, I think I worked on a number of projects where the government, in a sense, tried to channel the application of these doctrines based on the purposes of the statute and their history, in order to try to yield more predictable results and not to disrupt the treatment of transactions where the policies of the statute didn't require it, but rather to produce results that were more certain and were more likely to be, understood and therefore the same for all parties. Some of those things be things like 1.368-2K, which I continue to believe is a really useful contribution and a good contribution to our tax law, and some of the other guidance about continuity of interest and remote continuity of business enterprise. And that's some of the work that I was very proud of in government. It is still fun to work with this in my current job, and I love doing it. I try to come up with the best and surest answers for my clients that I can.
Well, I think you've done a fantastic job at that, and I know a lot of people would agree. I think the regulations that you just mentioned are fantastic examples of that. The 368 regulations governing reorganizations, have really evolved and helped clarify a lot of ambiguities for taxpayers over the years. Beginning in '98, I remember there was some big changes with respect to shareholder interests and the continuity there, and then with the expansion of -2K and clarification, there was just so much guidance that I think taxpayers across the board really appreciated. And so that brings me to another topic, which I think is interesting. I mentioned the regulatory changes that occurred in '98. Right around that time period, shortly before, we had some other significant changes that tie back into some prior points that we were making with respect to substance over form in some ways. and those are the check the box regulations. The check the box regulations really changed the name of the game for a lot of taxpayers with respect to how they approached their ability to move in and out of corporate status, form and liquidate corporations, and so I'd be curious as to your thoughts as to how those regulations evolved and how they've changed things going forward after they were issued.
Well, the corporate group, I think, was the only group at the in the chief counsel's office that I believe did not work at all on the initial project, which was an entity classification project, and was attempting to create certainty about the classification of entities under U.S. and foreign law. At the time, LLCs were relatively new in the U.S., and the government would review every state statute as it was adopted. And there were also issues under foreign law, so that back then you could have a Dutch BV and it would be a corporation for U.S. tax purposes if you had certain clauses in its documents, and it could be a partnership if you had different clauses. And in working that project, I'm sure it made sense to have an elective regime. It was an advancement, but in a way there was a certain amount of electivity given the pliabilities of some of these forms, especially the foreign ones. And of course, there was always a question lurking about the treatment of single owner, or the potential to have single owner flow through entities. Something you couldn't necessarily have under U.S. partnership law, perhaps, but nevertheless, was something one could theoretically conceive of in various ways, and I think it was sort of always there, and I suspect that the people who thought that they were working on this just thought, well, it's a question there to be answered, as opposed to a way to dramatically change the law or the world, in fact, or the way we practice in ways that they could never have imagined. And so, in a way, it was probably all a glorious accident, although, I wasn't there to actually say that for sure. The corporate group finally did get involved once people realized, well, somebody has to tell us what happens when you go between here and there. And we did get involved in that project as a follow-on to the classification regs. Since then, of course, it's really changed the way that people can organize their business affairs, and has proved to be a very useful tool in a lot of transactions. But I think in the end, the world has adapted to these regulations in a relatively healthy way, and uses them in ways that, by and large, are consistent with the intention, applies them in ways that are consistent with the intention of the underlying statutes, and just they become, in a sense, an easier way to reach a lot of results that you should have been able to reach anyhow, and that we've been able to do that with just enough, but not really too much agonizing about the fact that we are basically dealing with tax elections instead of longhand transactions. But I think by and large, our country has adjusted to this regime in a healthy way. So that even if the results might have been unexpected or surprising to the people who actually design the regulations, they should nevertheless feel proud of them.
Well, I certainly can't disagree with any of that. I know moving from the four-factor Kintner regulations to something that was much more accommodating and simpler, especially given just the trend, as you indicated, that was going on throughout the states as well as the world, and the difficulties that were, arising. I know one thing that we'll explore in future video casts on Willis Weighs In is just how regulatory changes like the check the box regulations can lead to unanticipated results and complexities that can be challenging. To your point, I think with respect to the check the box regulations, most of those issues are understood and generally agreed upon, but they certainly do present some interesting opportunities for taxpayers. There's of course a retroactivity period of 75 days. It is a tax election, and yet we do have step transaction principles that are incorporated into those rules. And so sometimes that can create some interesting issues. But by and large, I must admit, they certainly helped a lot in simplifying the tax administration and reaching conclusions and helping folks understand their tax obligations, which I think is critical to the system and is really what I think you have been given so much credit for. Not the check the box regulations, but just the simplicity that and help that you were able to provide taxpayers in understanding what their tax obligations are. Bill, I think it was so great of you to agree to join me today for this discussion. I'm so happy that you did, and I'd like to thank you again for joining us today.
Ben, it was my pleasure to get together with you today, and I look forward to watching many more of your podcasts and reading your articles. Thank you.
Thank you so much, Bill. Well, you've just listened to a discussion with Bill Alexander, and thank you for doing that. Feel free to reach out to me with any questions, as always. You can contact me at ben.willis@taxanalyst.org or on Twitter at Willis Weighs In. Thank you so much.
Willis Weighs In.